आपने अच्छी बहस करी, लेकिन सीज की और बैच नंबर अगर नहीं लिखा तो वो भी गलती है आपकी पुलिस की. दैट मीन्स दैट दे आर ट्राइंग टू सेव समबडी. बैच नंबर, एक्सपायरी डेट, उससे पूरा 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 मटेरियल ट्रेस हो जाएगा.
This is second regular bail application.
जी.
The applicant has been charged under section 8, 21 and 22 of the NDPS Act and section 5 read with 13 of MP Drug Control Act. Lordship. The first bail application, Lordship, was withdrawn. The applicant has been in custody since 29th of January 2022, Lordship.
1280 cc है.
1280 cc. Now the role of the applicant was that, Lordship, he was just present in the car. He was riding on the seat which is just beside the driver's seat, Lordship. The driver is co-accused Vishnu Dwaj Singh, and the owner of the car was also in the car. He is Kuldeep Saket. Lordship, my submission is there are two submissions, Lordship. One, that the seizure witness has turned hostile, Lordship. I have presented his statement.
तो इनके सारे witness hostile हो जाते हैं. That they are required to introspect. All their seizure witnesses are hostile. I have not come across a single case जहाँ seizure witnesses support किया हो. इसीलिए शायद ऑनरेबल सुप्रीम कोर्ट ने कहा कि ये जो है आईओ के बयान बड़े अहम रहेंगे.
अहम रहेंगे, Lordship, but not conclusive, Lordship. Apart from that, Lordship, my second submission is that according to the case of Avtar Singh, Lordship, 2002, volume 7, 419, this is the judgment, Lordship. It talks about, Lordship, about the conscious possession of the substance. If you see para number 6, Lordship, shall I read?
Please.
Possession is the core ingredient to be established before the accused in the instant case are subject to the punishment under section 50. If the accused are found to be in possession of poppy straw, in that case, Lordship, it was a case of poppy straw.
Quantity भी commercial बहुत ज़्यादा होती है, 100 किलो होती है शायद.
जी, Lordship. जी, Lordship. However, it talks about the point I am referring to.
Legal point.
Yes. Conscious possession, Lordship. Which is a narcotic drug within the meaning of clause 14 of section 2. It is for them to account for such possession satisfactorily. If not, the presumption under section 54 comes into play. We need not go into the aspect whether the possession must be conscious possession. Perhaps taking a cue from the decision of this court in Inder Sen versus State of Punjab, arising under the Opium Act, the learned trial judge charged the accused of having conscious possession of poppy husk. Assuming that poppy husk comes within the expression poppy straw, the question, however, remains whether the prosecution satisfactorily proved the fact that the accused were in possession of poppy husk. Accepting the evidence of prosecution witness 4, the head constable, it is seen that appellant 3, accused 4, was driving the vehicle loaded with bags of poppy husk. Appellants 1 and 2, accused 1 and 2, were sitting on the bags placed in the truck. As soon as the vehicle was stopped by ASI PW2, one person sitting in the cabin by the side of the driver and another person sitting in the back of the truck fled. No investigation has been directed to ascertain the role played by each of the accused and the nexus between the accused and the offending goods. The word possession no doubt has different shades of meaning and it is quite elastic in its connotation. Possession and ownership need not always go together, but the minimum requisite element which has to be satisfied is custody or control over the goods. Can it be said on the basis of the evidence available on record with the 3 appellants, one of whom was driving the vehicle and the other 2 sitting on the bags, were having such custody or control? It is difficult to reach such conclusion beyond reasonable doubt. It transpires from the evidence that the appellants were not the only occupants of the vehicle. One of the persons who was sitting in the cabin and another person sitting at the back of the truck made themselves scarce after seeing the police, and the prosecution could not establish their identity. it is quite probable that one of them could be the custodian of the goods, whether or not he was the proprietor. The persons who were merely sitting on the bags, in the absence of proof of anything more, cannot be presumed to be in possession of the goods. For instance, if they are laborers engaged merely for loading and unloading purposes, and there is nothing to show that the goods were at least in their temporary custody, conviction under Section 15 may not be warranted. At best, they may be abettors, but there is no such charge here. True, their silence and failure to explain the circumstances in which they were traveling in the vehicle at the odd hours is one strong circumstance that can be put against them. A case of drawing presumption under Section 114 of Evidence Act could perhaps be made out then to prove the possession of the accused. But the fact remains that in the course of examination under Section 313 CRPC, not even a question was asked that they were the persons in possession of poppy husks placed in the vehicle. The only question put to them was that, as per the prosecution evidence, they were sitting on the bags of poppy husk. Strangely enough, even the driver was questioned on the same lines. The object of examination, thereafter, Lordship, it starts talking about the scope of Section 313. Over here, Lordship, even I'm making the same submission. The driver was in the vehicle.
ओनर वॉज इन द वीक
Owner was
आप क्या ग्रेजुएट पैसेंजर थे? ये जो जजमेंट की थीम है वो ये है कि अगर कोई लेबरर बैठा हुआ है जिसको नहीं मालूम कि उसको क्या सामान उतारना है, तो सिर्फ ये मालूम है कि जगत सिंह साहब का सामान ट्रक में जा रहा है, मुझे उसको उतारना है, ठीक है, देन ही कैन नॉट बी said to be an accused because he was neither having constructive custody nor the actual custody. This is the ratio of the law laid down in this case.
Exactly.
अब आपको अपनी हैसियत बतानी पड़ेगी, आप किस हैसियत से बैठे थे गाड़ी में, आपने लिफ्ट ली थी, आप ग्रेजुएट पैसेंजर थे?
Lordship, I had taken a lift because
अच्छा कहाँ आया है आपका? मेमोरेंडम में पढ़िए, चलिए इनका मेमोरेंडम पढ़िए.
Lordship, memorandum will always be against me. In fact, I will.
अरे इतना तो आएगा कि मैं इस गाड़ी में फलानी जगह से बैठा फलानी जगह पे उतरने के लिए.
I in fact myself submit, Lordship, that the memorandum of the present applicant is similar to the co-accused persons, whereby he has declared that he purchased this the substance from a shop in the UP, which he does not remember which shop was it. Thereafter, they have kept the substance within the trunk of the car and beneath the back seat of the car. And he himself shows that if you come along, I will show you the substance. That is what is there in the memorandum, Lordship. However, I submit that it is inadmissible. Apart from that, Lordship, the onus is on the prosecution.
अभी आपकी गवाही कहाँ हुई है?
अभी गवाही नहीं हुई, Lordship.
गवाही होगी तब हम बताइएगा.
Lordship, for that instance, Lordship, I have brought this one order of the High Court of Odisha, Lordship, whereby bail was discussed. If Lordship may see para 8 onwards.
Yes. Please पढ़िए.
Section 20B, para 8, Lordship.
Yes.
Section 20B of the NDPS Act makes possession of contraband articles an offence. Section 20 appears in Chapter 4 of the Act, which relates to offence for possession of such articles. It is submitted that in order to make the possession illicit, there must be a conscious possession. It is highlighted that unless the possession was coupled with requisite mental element, that is conscious possession, and not mere custody without awareness of the nature of such possession, Section 20 is not attracted. Honorable Supreme Court in the case of Avtar Singh.
Yes, again this.
Again, that is repeated, Lordship. Now in paragraph number 10, Lordship.
Yes.
The order discusses another judgment of the Supreme Court. Saurabh Khan, Gandh Khan Pathan and another versus State of Gujarat. It reads as follows, Lordship. However, we notice that so far as accused one, appellant one here is concerned, the contraband in question has been seized from his possession. And in our opinion, the prosecution has established the case against the said accused, and the courts below have rightly convicted the said appellant. Whereas in regard to appellant 2, it is the prosecution case itself that he was traveling in the auto rickshaw along with 3 other persons 9 months. And on the said submissions, I ask for the mercy of the honorable judge.
Yes, Mr.
मतलब 8 कार्टून में 1280 एसकेप नशीली सिरप पाई गई है सर. कीमत करीब 2,44,000 की और 3 एक्यूज हैं, ये बाजू वाली सीट पे बैठे हुए थे ड्राइवर की.
ये तो उन्होंने खुद ही बता दिया.
जी सर. और
आप लोग जाकर ये इससे कितनी बार आपको बताना पड़ेगा, ना बैच नंबर से ना उससे ट्रेस नहीं करते कि कैसे ये दवाइयों का जो है ट्रांजैक्शन हो रहा है. क्या अब कोर्ट बंद करके क्या इन्वेस्टिगेशन कैसे किया जाता है इसका शुरू कर दें क्या? How these medicines are given in custody of unauthorized persons who are neither pharmacists nor licensees. नीचे मुंडी झुकाने से काम नहीं चलेगा, उत्तर देना पड़ेगा। आप तो बहुत अनुभवी हैं।
सर इसमें मैं देख रहा हूँ कि इसमें बैच नंबर है कि नहीं, वो ये देख रहा हूँ सर।
सीज किया और बैच नंबर अगर नहीं लिखा तो वो भी गलती है आपकी पुलिस की। दैट मीन्स दैट दे आर ट्राइंग टू सेव समबडी। बैच नंबर, एक्सपायरी डेट, उससे पूरा 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 मटेरियल ट्रेस हो जाएगा।
लिखा हुआ सर बैच नंबर।
फिर उसके बाद क्या किया इन्होंने?
जिसका बैच नंबर LE8।
मुझे बैच नंबर से मतलब नहीं है
सर।
बैच नंबर को फिर कहां से ट्रेस किया इन्होंने? ये दवाई कहाँ गई थी? मैन्युफैक्चरर से स्टॉकिस्ट के पास, स्टॉकिस्ट से किसको गई, और फिर वहां से ये कैसे निकली? पूरी चेन तो पकड़ी है आप चेन क्यों नहीं कंप्लीट करना चाहते हैं? जगत जी अभी वेट करिए, इनकी चेन पूरी करवा दें, उसके बाद में फिर आपको देखेंगे। श्री जगत सिंह, लर्नेड काउंसिल फॉर द एप्लीकेंट सुमित द्विवेदी। This is second bail application on behalf of each and every person in that chain.
ठीक है सर।
नंबर 3 साहब वर्मा, आपने अच्छी बहस करी, लेकिन
I understand.